Okay, for everyone deep in UPSC prep right now, you know how vital it is to cut through the noise and get straight to the point on key polity developments.
Absolutely. Time is precious.
Exactly. So today, we're doing just that. We're diving deep into a really significant Supreme Court judgment, the state of Tamil Nadu versus the governor of Tamil Nadu.
And significant is the right word. This isn't just another case. As the analysis in the Hindu really lays out, this judgment touches on some fundamental aspects of our constitutional setup.
Things like federalism, separation of powers, the big stuff.
Precisely. It redraws some lines, you could say.
Right. So we've gone through the Hindu's analysis to pull out the absolute essentials for you, the core issue. It's all about the role of governors and the president, too, when it comes to signing off on state laws. Giving assent.
That whole process, yeah.
Our mission here is simple. Give you the critical takeaways from this judgment. Help you understand what it means for the federal structure, how laws get made, and importantly, for your UPSC exams. Think of it as a shortcut through a complex topic.
A very necessary shortcut, I'd say.
Agreed. So let's get right down to it. What's the absolute heart of this Supreme Court decision? The main thrust.
I'd say the biggest thing, really, is the court stepping in on executive inaction. When bills just sit there.
Right, the waiting game.
Exactly. The court used Article 142, its power to do complete justice, to actually set time limits for governors and the president to act on these state bills.
Time limits set by the court. That sounds impactful.
It is because, well, it seems procedural, doesn't it? But it directly questions whether the executive can just indefinitely delay things. It sort of shakes up that traditional idea of separation of powers, at least in this specific area of legislative assent.
So it's not just a nudge, it's putting actual boundaries on that executive discretion within the lawmaking process. Okay. And this whole thing revolves around specific parts of the Constitution, right?
Yeah.
Articles 200 and 201.
Absolutely. They are the linchpins. Articles 200 and 201. The court's reading of these articles is what changes the game, especially on those timelines we just mentioned, which were, frankly, quite ambiguous before.
Ambiguous enough to allow delays, perhaps.
Well, that's the argument. A key point the court made was calling governors constitutional functionaries, not, independent agents with a veto power they can wield however they like.
Functionaries, not roadblocks.
Yeah.
Makes sense. So what did the court actually rule about these articles? What's the practical change?
The bottom line is this. Neither the governor nor the president can just sit on a bill forever. No indefinite delays, period. This really recalibrates that balance between the state executive and the state legislature.
Okay.
And the court was very clear. You can't interpret Articles 200 and 201 in a way that lets the governor just stall the whole legislative process simply by doing nothing.
Which feels intuitive, I suppose, if an elected body passes a law.
There has to be a clear process for it to potentially become law, yes. So the judgment says a governor has to return a bill for reconsideration within a reasonable time. And here's the kicker. If the legislature passes it again,
they send it back unchanged.
right, then the governor must give assent. It's not optional at that point.
Okay, that's a definite limit. And for the president under Article 201?
Similar logic applies. The president can assent, withhold assent, or send it back for reconsideration, but the court implies these actions also need to happen within a reasonable time frame. The goal was clearly to close those procedural loopholes that allowed for, well, stalling.
Right, closing the door on inaction as a form of veto. Now, this sounds like the court being quite proactive. How did they justify this interpretation? Was it seen as judicial activism?
That's the interesting part. The court framed it as a progressive interpretation. They'd argue it's not really making law, but interpreting the existing Constitution Articles 200 and 201 in a way that makes sense for today's democracy, addressing a real problem, legislative gridlock caused by waiting.
So adapting the Constitution's spirit to modern challenges.
Kind of, yes. A purposive reading. They look at the purpose behind the articles. The court pointed to a history of this kind of dynamic interpretation, mentioning landmark cases from, A.K. Gopalan way back when, right up to K.S. Puttaswamy on privacy.
Right, the living tree idea of the Constitution.
Exactly. In this specific case, they felt they needed a panoramic view looking beyond just the words on the page to protect what the state legislatures, the elected bodies, intended.
And was this idea completely out of the blue? Or were there precedents recommendations?
Oh, definitely not out of the blue. They drew heavily on things like the Sarkaria Commission reports, which have talked about these center state issues for ages. And crucially, they reaffirmed the principles from a really important older case, Shamshur Singh versus State of Punjab.
Ah, the aid and advice case.
That's the one. It established that governors generally act based on what the elected state government advises. They don't just use their personal discretion to block laws willy-nilly. So that precedent was key here.
Okay, so the governor's actions should generally align with the elected government. Now, you mentioned something else interesting, reasoned orders. What's that about?
That's huge for accountability. The court said just withholding assent, a simple no with no explanation, isn't good enough anymore. Simpliciter withholding, they called it.
So no more silent vetoes.
Pretty much. Both the governor and, by implication, the president need to give actual clear reasons if they decide to withhold assent from a bill passed by the legislature.
Why they're saying no.
Exactly. It chips away at any idea that these high offices are totally immune from scrutiny in the legislative process. It reinforces that everyone, every constitutional actor, is under the Constitution and subject to judicial review. The court even linked this back to Article 142, saying complete justice means making sure democracy isn't derailed by procedural tricks and delays.
And there was this idea of deemed assent, too. That sounds like a big step.
It does, and it's an example of what the analysis calls creative construction. It's not explicitly written in the Constitution, but the court sort of floated this idea that if a bill isn't returned or acted upon within a reasonable time, maybe it should be considered as if it received assent.
Wow. Okay, so a way to break the deadlock if inaction persists.
Precisely. A pragmatic tool, even if not literally spelled out in the text. It's all aimed at preventing the legislative wheels from grinding to a halt indefinitely.
This definitely sounds like it strengthens the hand of the legislature and pushes for more transparency. But surely not everyone agrees. Has there been pushback?
Oh, yes. There's been criticism. The analysis mentions, for instance, the governor of Kerala arguing this is judicial overreach, stepping into the territory of the executive and the legislature.
The classic separation of powers argument.
Right. That the judiciary is essentially making policy or setting rules that should be decided elsewhere.
But the counter, as you said, is that the court sees itself as just interpreting and applying the existing rules to make them work.
Exactly. That viewpoint frames it as constitutional pragmatism. You know, the court had to step in to fix a functional problem and uphold democratic norms using the tools the Constitution already provides. Not really legislating, but ensuring the system works.
Okay. Now, the Hindu's analysis didn't just explain the judgment. It also highlighted some constructive suggestions or observations that came up around it. What were those?
Yeah, a couple of interesting points. One was about the judgment itself, its length, 414 pages.
That's a lot of pages.
It is. And the suggestion raised was whether, for such critical constitutional rulings, maybe shorter, more focused judgments might be better. They pointed to the UK Supreme Court's Miller decision on Brexit. I think it was around 24 pages.
Much more digestible.
The idea being clarity and speed are really important, especially when things are politically charged or constitutionally uncertain. A quicker, clearer message.
Makes sense. Get the core ruling out faster. That was the other suggestion.
The second one was more about the court's own internal processes, how it handles these types of cases.
Efficiency, basically.
Yeah. The fact that Kerala had to come back after this verdict with a related issue sort of highlighted this. The suggestion was maybe grouping similar constitutional matters, especially those involving governor's powers or legislative processes, before a single bench.
For consistency.
And speed.
Exactly. Consistency in rulings and perhaps a more streamlined, efficient way to deal with these recurring, important constitutional questions.
Right. Developing a consistent line of jurisprudence. Okay, so bringing it all together now for our listeners, the UPSC aspirants burning the midnight oil. What are the absolute must-know takeaways from this deep dive for their exams?
Okay, for UPSC folks, this is gold. Seriously. First, understand the redefined powers and, crucially, the limitations of the governor and the president regarding assent to bills. Big topic for polity.
Definitely.
Second, how this impacts federalism. The balance between the union and the states, particularly the governor's role, acting sometimes seemingly in tension with the state government.
Third, judicial review in action. This is a prime example of the judiciary interpreting the Constitution and checking executive power. Fourth, the balance of power itself between legislature, executive, judiciary, this case, shifts it subtly.
And those specific articles.
Absolutely critical. Articles 200 and 201. You need to know not just what they say, but how this judgment interprets their practical application now. Understanding this whole dynamic is vital for prelims, sure, but especially for mains and answers on governance, polity, and constitutional issues.
It really highlights that knowing the text isn't enough. You need to know the interpretation of the living law. So wrapping up, what's the big picture significance here?
At the end of the day, this judgment from the state of Tamil Nadu versus governor of Tamil Nadu case, it really tries to reinforce democratic accountability. It tackles that gray area of executive inaction in the legislative sphere.
Saying doing nothing isn't really doing your constitutional duty.
In essence, yes. By giving a purposive interpretation, the court aimed to make sure that elected state legislatures aren't just left hanging, their laws stuck in limbo indefinitely. It's about making the process work as intended.
A really important clarification for how our democracy functions. And it certainly leaves us thinking, doesn't it? How will these time limits and expectations play out on the ground? What's the next evolution we might see in interpreting these powers? Definitely food for thought.
For sure.
All right, for all of you focused on your UPSC journey, we really hope this deep dive, rooted in the analysis from the Hindu, has clarified this important judgment. If you found it helpful, please do give us a like, subscribe for more, and definitely drop any questions you have in the comments below. Engaging with this stuff is key for cracking both prelims and mains.
Keep asking questions.
Absolutely. Thanks for tuning in to this deep dive.